That's exactly what is the problem.
That's exactly
There is no problem. You don't have to.
You can't have this kind of second bite at the cherry.
Judges say Basha is wrong. What else?
We can't deal with 7-judge bench like this, my lord, that you decide what is comfortable to me and don't
I
decide
think you are more hurt about it than the 7 judges.
Both should be decided together. That's the appropriate.
Lord, the reference is the matters are referred.
On this, we'll just defer it a little bit. You conclude your arguments. We'll also read Basha with you. Once we reread Basha with you, you would have read Basha with two different perspectives.
I need to read, my lord, some debates in 65 and that, my lord, that would be very crucial.
All right. So now after this, you'll be referring to the debates.
Yes.
And then directly take us to Basha, or what's the?
Yes, that's the.
And then we'll conclude.
There is only one thing I must.
So I guess about 20 minutes for the debates and about half an hour.
I'll take, my lord, 7 sessions. I'll not repeat anything. Not repeat anything.
So, but now what remains from your argument is the debates and then followed by Basha.
Basha and, my lord, few other points.
So there is only one thing I must point out: the legal obstacle for them is the court suggested by them. If Lord Basha is to be considered independent, not in the right of 81, virtually these proceedings will be sitting, Lord, like an appellate proceeding.
That is going to be my submission.
Principle, Lord, larger bench can go into the ratio, not the decision in that case. That's what.
Not the factual findings. That is going to be my submission.
To convert the reference Lord into an appeal.
This is not an appeal from 5-judge bench to 7-judge bench intra-court appeal. The argument was, look at this what he says, look at this what he says.
In fact, madam, that's going to be one of my submissions.
We'll presently be open unless until we read Basha. Until we read Basha with the Solicitor General. Let's because ultimately a judgment also depends on how it's how it is interpreted by both the sides. So let's read Basha with you, and then we'll take a final call.
And one more anomaly, my lords, reflect on that, my lord. Just one more anomaly. Assume, my lords, my lords decide that Basha is rightly decided. By relegating the 81 question to a smaller bench, they will get the opportunity to argue that notwithstanding Basha, 81 amendment is declaratory and curative. Therefore, Basha will not apply. Please see the anomaly. Then 7 judges will upheld Basha, and thereafter
have choice of 2 litigations, my lord, in a matter which are inseparable.
And again, anomalously, my lord, they argue what is something contrary to what is decided.
We'll not conclude an opinion at this stage. Let's because solicitor is on his legs now. And we have almost substantially completed the arguments. One more session is what he requires. So today we'll finish anyway, even by his own.
One aspect also can be kept in mind, that is the referring order in the last paragraph refers the whole matter to your lordships. It says consequently we refer the whole matter.
We'll just look at that.
Same time, the appeal has been filed by the Union against the Aligarrh.
Yes, my learned friend is right, factual. And thereafter, Government of India, on a considered decision, filed an affidavit saying that we are not pressing this appeal. And we are supporting, when you say the full truth,
And
not half
so
truth.
technically on paper it remains the appeal.
It remains,
Subject
appeal remains.
Your appeal that
I have
you
not
don't
been
want to
permitted to withdraw the appeal, but it is the stand of Union of India that judgment of the division bench is true.
And there's an appeal by AMU also.
Yes.
Separate appeal.
Several. There are several.
General, in case we go into 81 amendment, then this issue will arise. Whether a legislative act or an amendment made by the parliament, subsequently you can withdraw. That will be an issue.
Correct, man. Correct. And I'll have to address that, man. I'm not running away from that question.
Correct. And there are 2 options before us. Either we accept the ratio in Basha. In case the ratio in Basha is accepted, then we come to 3 conclusions. It's de jure established by a statute and not by the minority committee. It is de facto established not by the minority committee. 3, it is not administered by the minority committee.
And 4, surrendering.
Surrendering is part of 1, 2, and 3.
Yes.
1, 2, and 3.
A lot of people subsumed that.
It's subsumed in that.
Yes.
It's an argument dealing in support of that. Now, as far as 1981 amendment is concerned, it only deals with de jure, first part of it, de jure establishment of a, or establishment of the bias statute. It doesn't deal with the other two. 81 amendment does not touch. And if I'm not mistaken, when we read Basha, it deals with all the three contentions.
Correct.
I think you're also of the opinion it deals with all the three situations.
Yes.
De jure, de facto, and administer.
Correct. Your Lordship, sir. My Lord, now,
If Aziz Basha is declared to be right by your lordships, then we would have to take recourse in 81. That's separate issue.
that's the whole point.
That is something, what is the effect of 81 amendment? That may have to be sent back to the High Court itself for fresh consideration.
No. It will be before a regular.
Decided here.
That will be a separate, let's not open up a new debate.
Quite right, Lord. Quite right.
Lord, the position will be this, and I leave it at that. I leave it at that. My Lord, the position will be like this. If they succeed, they get a second chance before a regular bench. If we succeed, then there is no chance. If they lose, I'm sorry, reverse. If they lose, they get a second chance. If we lose, we lose.
No, Mr. Mehta probably be a very limited chance.
Lord, your Lordship knows the ingenuity, my Lord. This is pending since years.
Because if we uphold on the second and third principles, Basha, even if they succeed on the first part, that statutory establishment has been taken away.
Lord, on that, we have sufficiently assisted your Lordships, whether to take it up here or wait. It is entirely your Lordship's
We'll
call.
just take it
I'll
on.
not.
We'll also like to read Basha with you, and then I think.
Lord,
we can
before
pick up
that,
again.
Lord, what I have done is, Lord, I desired to read the entire debate of 65, amendment of 1965. But with a view, my Lord, not to curtail, my Lord, with a view to curtail my time, my Lord, I will read only one, where the Honorable Education Minister, Justice Chagla, my Lord, summarizes. Justice Chagla was, my Lord, dealing with my Lord, member of Parliament called Frank Anthony, who had appeared in Kerala
He
education.
was a member of our bar.
Yes.
Yes,
Very
he was a,
Outstanding.
vibrant member of our bar.
yes, he was a, there are some
As a
interesting,
young lawyer, I've heard Mr. Anthony argue actually, Frank Anthony argue.
Lord,
The school is named after him, the Frank Anthony.
yes. Lord, he was
Yeah, he established.
a nominated member as an Anglo-Indian community. He was a nominated member as an Anglo-Indian community. My Lord, in fact, there is a very beautiful and interesting exchange between Justice Chagla and Frank Anthony, my Lord. Because both were, my Lord, were from the same field. But the Justice Chagla had to say that you will have to concede that I know a little law, including the constitutional law. That's what Justice Chagla said in the debate, my Lord. And, Lord,
All right, let's see, what are we seeing next now?
my Lord, please come to, my Lord, my note 2B. My Lord, I am reading only one paragraph of Justice Chagla's, my Lord, address,
This is the parliamentary debate.
parliamentary debate in 65 amendment, when the 65th amendment was introduced. This is inter alia what he said. My Lord, what he does is,
Mr. Solicitor, page.
I'm sorry, my Lord, page 111 at the foot. But Justice Chagla narrates the history. Justice Chagla does two things. He narrates the history, which I have broadly pointed out to your Lordships. And second, he says that there is a reason why our constitution makers have given them a separate status in the constitution itself as institution of national character. And thereafter, my Lord, he says this, Lord, at the foot, 2nd September 1965. Your Lordships would recall.
Can I request you, by chance I opened up a wrong page.
2B.
I'm 2B. That's a speech of Monana
Azad. That's right.
on, can you just read that also?
2B, my Lord.
It's 2B, triple
Right,
one.
111, it's the,
Can you
No,
just
page
read
your
that?
Lordships open.
Triple one.
Triple one. I agree. Maulana Azad, my Lord, that is 51 speech.
Yes, yes.
My Lord, I wanted to read that, but I was curtailing myself. My Lord,
Let's see.
if your Lordship, my Lord, permits. As far as our constitution is concerned, honorable members are aware that Article 28(3) lays down that religious instruction cannot be made compulsory in any government institution. This necessitated a reconsideration of the question as far as these two universities are concerned. In both the universities, the Hindu university and the Muslim university, the religious instruction is compulsory. This was against the Article 28 of the Constitution and necessitated the making of certain changes. So the first change that is made is that religious instruction to be made optional. Instead of being compulsory, religious instruction will be given only to those students who themselves would ask for it. The honorable members are aware that a majority of students who get themselves admitted to these universities are such as want religious instructions being given to them. Another change has been made on the basis of recommendation of Universities Commission. The Commission recommended that in future, the President of Indian Union should be the visitor of all central universities. Having those powers with the Lord Rector and the Chancellor enjoy, it is against the spirit of our Constitution that the character of an educational institution be allowed to remain communal. All the institutions in the country should be Indian from all points of view and not Hindu, Muslim, Sikh or Christian. Naturally, the question that arose before the government was asked to what attitude they should adopt regarding the names of these two universities. The honorable members may be aware that about 2 years back in 1949, the government intended to introduce a bill consisting of only two clauses, one stating that the name of these two universities be changed from Banaras Hindu University and Aligarh Muslim University to Banaras University and Aligarh University, respectively, and the other making it clear that non-Hindus and non-Muslims can also become members of their courts. Nevertheless, the government prepared the draft bill and elicited the opinion of both the universities regarding that. The Muslim university was of the opinion that having been assured that general policy of the government was to change the communal character of the university, it would have no objection if the word Muslim was deleted out from its name and it being called Aligarh University instead of Muslim University.